Well, hi, everyone. Thank you very much for joining this month's Zoom immigration meeting. It's a beautiful day here in Michigan and hope it's a wonderful day where you are also. First, I'd like to say a couple thank yous, as always. First, to my assistant, Carolyn Taylor, who did a terrific job in helping to put this together. Carolyn is awesome and always does a wonderful job in helping me to prepare for these. So, Carolyn, thank you very much for all of your help. And then also thanks to Jeff Bumbales for his technical assistance and to my son, Eric Sherman, for all of his help as well. So again, thank you for joining us today. And the topic today is going to be job search advice for residents and fellows. So we're not really going to talk directly about specific visas. This is more of a kind of a way to help you as residents or you as administrators and various residency or fellowship programs understand the ins and outs of looking for a job, what to look out for, what to beware of, and in terms of contracts and other matters. So without further ado, let's get started. And as always, if you have any questions, feel free to put them in the chat box or to email me afterwards. My email address and other contact information will be at the end of the slideshow. So without further ado, let's get started. So let's start by talking with contracts. So let's assume that you as a resident or fellow, or if you're an administrator, some of your residents or fellows have just found a job. Now, the most important thing is the contract, of course. No matter what type of oral promises the practice or hospital or other employer may have made or may be making, as we learn in law school on day one in our first year contracts class, if it's not in writing, it really doesn't exist. So handshake deals, oral promises to do this or that really are nice, but unless they're written or memorialized in a written contract, it's really as if they don't exist and often or usually not enforceable. So again, as you can see from the first bullet point, and not to beat a dead horse, again, everything needs to be in writing. Among other things, I mean, setting aside the legal aspects, let's say that someone makes an oral promise to you as a resident, and that sounds great. They will do this or that. They will pay you X amount of dollars or what have you. And then a week later, that person accepts a position with a different firm or a different medical office or hospital. So along with that person leaving, so did all of the oral promises. There may or may not be anyone remaining at the employer who knows about the promises or understands them or is willing to accept them as part of the basis of your job with them. So again, everything should be in writing. Now, in addition to the normal terms and conditions of employment, such as the rate of pay or where you'll be working, the type of malpractice insurance that you'll be receiving, it's really important that if you're currently holding any type of visa status, whether it's J1, H1B, you want a green card, etc., that these things are also put into the contract. In other words, it's not enough just to have a typical employment contract that would be issued to someone who is not a visa holder. So instead, it's really imperative that the contract talk about what the employer is going to do in terms of visas. Are they going to obtain an H-1B visa for you? Are they going to apply for a green card for you? And if so, when? It's one thing for a contract to say that the employer will sponsor you for a green card. Much more important, though, in addition to that, would be, well, when? Is there a 90-day waiting period? Is there a 6-month waiting period? Or is this something that the employer is actually willing to start for you the minute that you start employment with them? So this type of time frame is very important, especially as to the green card process, and especially now because there is a backlog in just about every green card category. And so from your perspective as the individual physician, it really is in your interest to have the employer start the green card process as soon as possible, rather than waiting 90 days or 6 months or even a year. It's much more important to try and get started soon. If the employer, for instance, says that, sure, we'll do the green card for you, but you have to wait a year, that's definitely something that you would want to take into consideration when determining whether this is really the right job for you, or whether instead you might be better suited by looking for a job with another employer that might be willing to start the process for you sooner. Now, the next big bullet point is all contracts are negotiable. And yes, there is an exclamation point after that. I say that because, and have the exclamation point there for a reason. And that's because as residents and fellows, your contract is not negotiable. The hospital gives you a contract. All of the terms and conditions are standard for you and all of your colleagues. And the only thing you can do really is to read it and sign it. You have no authority, no power to negotiate different terms and conditions, a different rate of pay, different working conditions, etc. It's very standard, which actually makes it easy for you because all you need to do is review it, sign it, and date it, and then you can move on and take care of your patients. Now, post-residency and post-fellowship contracts are exactly the opposite. Yes, an employer or prospective employer will give you a contract. Yes, it should have all kinds of terms and conditions that are beneficial both to the practice or hospital, of course, but also to you. But keep in mind that just because something is in writing at this stage, you can always negotiate. You can ask for changes. You can ask for things that might be missing, or perhaps other things, a different vacation, different malpractice coverage, etc. So it never hurts to ask, and actually you want to be an advocate. Now, what I normally do is to help with negotiations, I always suggest or recommend that residents and fellows obtain the services of a contract lawyer. Now, that would be a lawyer who specializes in physician contracts rather than just kind of run-of-the-mill standard contracts. This would be someone who understands the needs of physicians, understands the relationships between medical practices or hospitals and the physicians, and can be your advocate in negotiating with the employer to make sure that the contract provides you with what you need in terms of rate of pay, working conditions, vacation, and of course, malpractice protection. There are specific lawyers who do specialize in healthcare contracts, and those would be the people that you would want to consult with. Sometimes I get a question like, people are from different cultures, and in that culture, negotiations on this sort of type of contract is not something that is normally done. And they're worried that by trying to negotiate or ask questions about the contract as it is somehow going to make the employer upset, angry, perhaps wanting to revoke the contract or revoke the job offer. Nothing could be further from the truth. In the US, all employment agreements, or most of them anyway, are negotiable. And so you have the right to ask. It's really on you to step up to the plate, as they say in baseball, and ask for what you want. It's then up to the employer to decide whether they're going to grant you what you want or say, no, actually, we're going to keep that provision of the contract as it is. At the end of the day, based on the negotiations that you have with the employer, that's when you're going to make your decision as to whether you go ahead and sign the contract or whether perhaps you just walk away. I mean, if the changes that you've asked for, which are probably going to be very reasonable, are not made by the employer is sticking with their contract the way it is. At that point, you would have to make the difficult decision as to whether or not the contract as is, without the changes that you want, actually protects your interests enough, or is this a situation where, again, you'd be best to just walk away and try to find another employer that will be more reasonable in terms of the terms and conditions of the contract. Now, the last point on this slide talks about physician national interest waivers and J-1 waivers. So just a quick note on what these are. Physician national interest waivers, or PNIW cases, this is a type of green card application. It's only available to physicians, whether you're a primary care physician or a specialist. Either way is fine. But it's when you work in a medical shortage area, or agree to do so for a period of 5 years, you can pursue a green card through the PNIW route. And although this does require some input from the employer and also a 5-year contract and some other things, you're actually self-petitioning for your own green card. But with that in mind, the PNIW does require certain terms and conditions to be listed in your employment agreement. Without those terms, such as location and some other things, the PNIW can't be approved. Now, sometimes people will get a contract, it will be signed and done, and then later decide to do a PNIW. If that's the case, that actually is not a problem, as long as the employer is willing to issue a supplement or amendment to the contract that does include those terms and conditions that can be filed along with the contract that was already signed that does not include those terms and conditions. Now, looking at J-1 waivers, what we're talking about here are employment-based J-1 waivers. That is, waiver of the 2-year foreign residency requirement based on working in the US, normally for a period of 3 years, and normally in a medical shortage area or with a Veterans Administration hospital. Now, for the J-1 waivers that J1 waiver applications that go through certain agencies, whether it's a state Conrad 30 program or the U.S. Department of Health and Human Services or any of the other J1 waiver agencies. They all require certain terms and conditions to be in the contract, among other things, the exact location of work, and usually that the physician will work for a minimum of 40 hours per week in the shortage area for a minimum of 3 years. And again, if these items are not in the body of the contract, they can certainly be included in an appendix or addendum to the contract, but they have to be there. So if you're planning to get a J1 waiver and or physician national interest waiver, it's important that the contract at the beginning, as you're negotiating it, covers these items. It's much better and much easier to cover them at the start in these contracts, as opposed to, let's say, in the future, having to go back to the employer and saying, look, I really need to have some additional terms and conditions of employment put into an addendum or an appendix to my contract. The employer may be willing to do it, and that would be terrific. On the other hand, the employer may say, look, the contract that we have is a contract that we have, and that's it. We're not going to add anything to it. And that's the end of the story. So very important to look at all of these things. There is a lot there. And so again, helpful to have the help of a contract lawyer. And it's also, of course, helpful to have an immigration lawyer as well in terms of looking at the various visa and green card provisions that need to be in the contract. Okay, next, pay attention to the tone of the contract. Now, by tone, what I mean is this. When you review a contract, it should be or seem to you to be fair. In other words, it may not be perfect. It may not include everything you want. It may include some things that you don't want. But you really want to take a step back after you've read through the contract thoroughly and determine, is the contract fair? Is the employer trying to be fair? Is this a contract that is trying to protect both you and the employer? Or instead, is it a contract that is absolutely and totally one-sided? What I mean is the contract seems to give everything to the employer, all the protections, all the rights, everything else. And you are left, you as the physician are left with basically no protections, and all the terms and conditions are favorable to the employer and not you. So if you receive a contract like that, a red flag really should go up, because if you think the contract is bad, can you imagine what would happen if you sign it and then go work for that employer? If the contract is bad, the employment will likely be bad too, because you will see that you have no protections and everything is in the employer's court. And that will be a problem down the line for sure. Now, among other things, to look for, does it obligate and lock you in without obligating the employer in certain things? What is the process for quitting your position if you choose to do so? How much notice do you have to give? What is the process if the employer wants to terminate your employment? How much notice do they have to give you? Is it 30 days, 90 days? Can they terminate your employment without cause? And now the answer to that one, by the way, is usually yes. Just about every physician contract I've ever seen includes a termination of employment without cause. So that type of provision is something to look for, but it's not a killer to the contract. The employer wants the ability to terminate your employment for any reason or some reason, and by allowing them to do it without cause, it gives them the flexibility to do that. Now, of course, hopefully they won't do it, but that is a standard type of clause that you're very likely to see in any contract that you're being offered. Next, mediation or arbitration. And if so, who would be the mediator or arbitrator? What do I mean by all of this? Well, usually towards the end of the contract talks about what happens if there's a contract dispute. There's a term or provision of the contract that perhaps you believe the employer is not fulfilling, or on the flip side, perhaps they feel that there is something that you're obligated to do by the contract and you're simply not doing it. In that case, many contracts have a mandatory mediation or arbitration clause. Now, there is a difference, although the two items sound very similar. Mediation is usually where both sides meet with a mediator or a mediation panel, make their case. It's sort of like a small court hearing, so to speak, and then the mediator or the panel will make a recommendation to both parties as to how to try and solve this dispute. Arbitration, more more often than not called binding arbitration, is a little bit different. Mediation is a recommendation on settlement, a recommendation for both parties to consider what the mediators have decided might be a fair solution, rather than having to go to litigation or court action. Binding arbitration is totally different. It's similar in that it's a meeting with an arbitrator or perhaps a panel of arbitrators who come up with ways to settle the dispute. The difference is, however, that their finding is mandatory. It is binding on you. It's not as if it's just a recommendation of settling, but by signing this contract, you and the employer are subjecting yourselves to mandatory arbitration, meaning whatever the arbitrators come up with, that's going to be it in terms of settling this dispute that you have. So you want to know, is this required? Is it in the contract? And if so, does the contract name a mediator or name an arbitrator? Or what is the process for determining who's going to be the mediator or the arbitrator? These are all things that you'll want to look at and consider. I mean, of course, by signing a contract, it's your intention to fulfill the contract, and you're going to do so in good faith. And of course, you're also hoping that the employer also plans on doing what it is supposed to do under the contract. However, as they say, you always have to be prepared for a rainy day. That is a day when you may have a dispute with the employer, and then it's the contract that controls in terms of how is that dispute going to be solved, or at least what are the first steps that you have to take in solving this dispute with the employer. In addition, the contract may indicate which side would pay for mediation or arbitration, or are these expenses that both parties would split down the middle. Next, the question is whether medical malpractice insurance is sufficient. That's something that many regular standard contract lawyers would have no idea about. They might be able to help you with other terms and conditions of the contract, but in terms of the sufficiency of malpractice, in terms of the amount and the duration and all the other aspects of that, that's really something that a healthcare lawyer should help you address, make sure that your interests are protected completely. And lastly, the question is whether there are non-compete or non-solicitation provisions in these contracts. And if they are there, are they reasonable? And one other question that I should have listed here, not only are they reasonable, but are they mandatory? In other words, are these provisions that the employer throws in, hoping that you'll simply agree to them, and the employer at the end of the day really wants you to join the group, join the hospital, and so they are actually willing to sign a contract without these provisions, if you ask. But they put them in there hoping that you'll just agree to them, and that will be that. So let's talk about what they are. They kind of go hand in hand, but they are different. Non-compete. Now that's a clause or provision in the contract that talks about what you can't do once you leave the employment with this employer. In other words, can you set up your own medical practice down the street? What about somewhere else in the county or somewhere else in the city? And other aspects that an employer may view as you competing with them and you being a direct competitor to them. So non-solicitation provision goes hand in hand, but it's something a little different. And it's a clause or provision that talks about whether or not you may tell current patients of the practice or the hospital where you're working that you are leaving, or you are planning on leaving, or can you contact them after you've left by phone call, by letter, or what have you, and say, look, I just left, I'm setting up my own new practice, here's the address, I would love to continue taking care of you, etc., etc. So you need to look at these provisions very carefully. And of course, from your perspective as a physician, you will want to try and have them removed. If the employer removes them, that is terrific. Then you really can, if you want to, open up a practice down the street, somewhere else in the county, or what have you. You can also tell patients, hey, look, I'm going to be leaving. Here's my contact info, or I'm going to be leaving. Look me up on Google. My new practice will be on Google. Or later on, you could take names and addresses of patients that you've seen and send them letters saying, hey, I've opened my new practice. Here's my phone number to make an appointment if you want to do so. And this is how you would request your chart from the practice where I used to work. Now, in terms of non-compete, one thing that everyone needs to understand is that not every non-compete clause is going to be enforceable in a court of law. I have seen all kinds of non-compete agreements over the last 30 years. Everything from saying, okay, it's 1 year, you can't compete within a 5-mile radius or 10-mile radius. Others I've seen You cannot compete for 5 years in the Lower Peninsula of Michigan. Um, and you think to yourself, what are the boundaries? I mean, what is the time frame that this is enforceable? And really, I mean, is it really enforceable in a court of law that I cannot practice my specialty for 5 years in the entire Lower Peninsula of Michigan? So the way the courts traditionally look at these non-competes is the following, and it really depends state by state. So please don't take this as a blanket statement of law for all 50 states, but I can say, generally speaking, in all 50 states, that when courts review these clauses, they are looking for whether it is reasonable in time duration and reasonable in distance. In terms of protecting the practice. So saying that you can't practice for 5 or 10 years in the Lower Peninsula of Michigan, when that is where you live, of course, would be totally unreasonable. And definitely I can never guarantee anything, but I can basically guarantee that that type of provision is something that would not be upheld in a court of law. Other than that, there is case law specific to all of these matters in all the states. And again, usually the courts are looking for whether a clause is reasonable in time and also reasonable in distance. It's one thing to protect the employer. It's another thing to prevent you as a physician from practicing medicine in the state and then having to move out of state just because you're no longer working for this employer. So, and when I say that, judges look at it this way and litigation, that would tell you that if there's a dispute, it would be something that would wind up in court. You would file what's called a declaratory action without, on the contract. And then the court would have to decide if this non-compete should stand as it is, or is it so egregious and so ridiculous that the court needs to set it aside entirely or needs to modify it in terms of duration or location. So really the key as a physician is to try and remove these if you can. If you can't, then try to make sure that they're as reasonable as possible and that they're going to give you some freedom and some flexibility to leave and work for another employer or to set up your own practice should you decide at some point to leave, or should the employer decide at some point to terminate your employment with them. Really, at the end of the day, as it says at the bottom of this slide, if the contract is not fair, you may have issues in the future. Again, it's really the tone of the contract, the content of the contract. If it's not fair, if it seems like it's not fair and you sign it, you may regret it one day when issues come up and you need to solve them, and you look at the contract and remember all of a sudden by reviewing it that, this contract really does not provide me with help in solving this problem. Instead, it gives all the rights to the employer and lets them basically dictate the results of our dispute. Employer red flags. So we've kind of touched on this already, but let's go over this as some additional information. If the employer is totally unwilling to negotiate the terms of the contract and they have like a take it or leave it attitude, this is the contract, take it, don't take it, sign it, don't sign it, we don't care. If there are changes that you want and changes that you need, and the employer gives you this sort of brick wall, then it's really a red flag, and it is a signal to you that you should leave the negotiations. Forget about this job offer. Just move on and try and find a different job offer with an employer that will offer you a contract that is much more along the lines of what you need in terms of benefits and rate of pay and safeguards of employment. Now, I say this, the next point is after negotiations, if this contract is still unsatisfactory, you and your lawyer have gone back and forth with the employer or with the employer and its lawyer, and maybe they're willing to give on a couple things here and there. They're willing to make some changes. But at the end of the negotiations, they say, look, okay, this is all we're doing. This is the final version. What you have in your hands is the final version of the contract that we as an employer are willing to offer. We're just simply not willing to make any more changes, and that's it. At that point, that's really it. You have to make a decision. Do I go with this employer, even though the contract is not exactly what I wanted? Or is this good enough? It protects my interests well enough. I'm okay. And this is such a great opportunity. I should go ahead and take it. But you want to make sure when doing that calculation that you're not letting your emotions get the better of you. You're not saying, look, this job is in beautiful, sunny La Jolla, California. And so the contract is not great. I don't have all the protections I want, but hey, I'm going to be working in a beautiful part of the country where it's 70 and sunny every day. And that will make up for any contract deficiencies, any problems in the contract. It's all going to be fine because honestly, after going through med school and residency, this is my dream job and I'll just make it work. That is really not a good way to go because it may work or it may not work. And if it doesn't work, you're going to be in arbitration, mediation, litigation, some or all of those. And it's going to make your life miserable in the meantime, trying to get through this and move ahead with your future. Next, for those people who hold visas and will rely on the employer for a J-1 waiver, an H-1B, a green card, one of the biggest red flags I tell everybody is, the employer gets to pick the immigration lawyer because they've got to pay for most of this. Like the H-1B, the employer legally has to pay. Same with the J-1 waiver. Even if you're willing to, you as a physician willing to pay for the H-1B or the J-1 waiver, the employer by law is still required to pay for these things, and you're not allowed to pay or reimburse them. With that being said, it's in your interest, of course, to have a good relationship with their immigration lawyer, to touch base, to find out, to discuss your questions, and to find out what is the procedure, what is the game plan here for the J-1 waiver, the H-1B, the green card. Now, if the employer refuses to give you the name and contact information of the immigration lawyer, or if they do give you that information and then you try and contact the immigration lawyer, but he or she doesn't return your emails, doesn't return your calls, or maybe they do return your calls, but they just give you a very cursory response like, oh yeah, we're the immigration lawyer. Don't worry, we've got this, we'll take care of it. That's a real problem because your future in part is based on your visa status, your interest in staying here permanently and getting a green card and maybe going on for US citizenship one day is all dependent on what this lawyer will be doing for you over the coming years. Because all of this is a multi-year procedure, green card, H-1B, etc. If the immigration lawyer won't talk to you, won't answer your questions, or gives you kind of a cursory, don't call us, we'll take care of it, we got this, we've been doing this, etc. Really think seriously about moving on to some other job offer, because there will come a time undoubtedly, and I say this based on my 30 years of experience, where you will have a critically important immigration or visa question. It is something that you will want an answer to right away. Now, knowing that some immigration or visa questions really are urgent and others, we would like them answered right away, but it's not urgent at this very second. But there will come a time when there is something urgent and you'll need some advice. And if this lawyer is not going to be available to you, you're going to be stuck trying to look this up online on Google or on the USCIS website or talking to friends or what have you. These are all methods I would not recommend. Calling the immigration service, if you call them 5 times, you will get 5 different answers, none of which may be right. If you look it up on Google, you might be looking at information that is helpful. On the other hand, it could seem helpful, but it could be outdated, or it may actually apply to some other types of cases that really are not your exact situation. Of course, there are chat rooms where people put up their thoughts and ideas and suggestions and what happened to them and all this, and sure, that can be somewhat helpful in Reddit and others. But on the other hand, you really want the professional, you really want the immigration lawyer to contact you back and give you a formal official answer so that you can deal with whatever situation you're facing. And so you can also sleep at night. If they're not willing to communicate with you meaningfully and timely, don't accept this job offer, because once you do sign the contract, I can guarantee you, if they didn't contact you back before you signed it, they certainly will not do it after you sign the contract. Next, if the employer won't put immigration provisions in the contract and offers only oral agreements, again, as we said at the beginning, everything needs to be in writing. If they won't put it in writing, this is not a contract you should sign because you could get burned easily. Also, for things like J-1 waivers and PNIW cases, it will not meet the requirements of the US government, and you're going to be in a really difficult situation. Lastly, and this is not necessarily a red flag, but if the employer is one who has never sponsored anyone for a visa or a J-1 waiver or green card, it's not necessarily a bad thing, but it's really important that they contact an immigration lawyer It could be me or it could be whoever, but that they understand the costs, the timeline, the steps that are involved, and the information and documents that they're going to have to divulge to the U.S. Immigration Service, the U.S. Department of Labor, and maybe even a Conrad 30 or other J-1 waiver program. I mean, there's a lot of information and a lot of documents that have to be divulged. And not every employer is willing to do that. Some are private and they don't want to provide any information to any governmental agencies unless they have to. And so when you go ahead with a J-1 waiver, or let's say you go ahead with the green card process, and at a certain point, the employer is required to provide a copy of their federal tax return. Well, if they're not advised of that at the beginning before you sign the contract, and all of a sudden it's something that you or the immigration lawyer springs on them, months and months and months into the future, you would have a real problem on your hands if they're not willing, the employer's not willing to provide a copy of that federal tax return or to provide other information. So it's important that the employer know what to expect, what's required, and what their obligations are during all of the steps and also afterwards. And so if they've never done this before you as a physician sign in a contract with them, you want to make sure that they reach out and speak to an immigration lawyer and understand what they're getting themselves into, and what to expect, what the lawyer will be asking them for throughout the process. Next, plan ahead. That's really what this entire slide is all about, planning ahead. If you want a green card or a J-1 waiver or an H-1B, etc. As we've been saying right along, it's really, really important to have a game plan, to plan ahead, make sure everything that you need is in the contract. But also, I mean, looking at the visas as like a playing field. I mean, you'll want to, like a football team, you'll want to have plays, you'll want to have a strategy, and you want to have a road ahead. You don't want to plan as you go. You'll keep hitting hurdles and bumps in the road, and some of them may be fatal in terms of the green card process or H-1B or J-1 waiver. So before taking one step forward, you'll want to have a game plan, and you want to know exactly what's going to happen, what to expect. For instance, let's say you're an H-1B worker, you've done a residency for 3 years as an H-1B. Okay, so you have 3 years of H-1B status left. It's important to understand that, and for the employer to understand that means the green card process needs to be started sooner rather than later, so that if it becomes necessary, you will qualify to extend your H-1B status beyond the normal or usual 6-year limit. If you get far enough into the green card process, it is possible to get extensions of H-1 status beyond that 6-year limit in either increments of 1 year at a time or 3 years at a time, depending on the situation in terms of the green card, and also whether or not there's a backlog in your green card category when the time comes. And as I've said a couple times, and I'll just repeat it one more time, ask the prospective or potential employer, when are they willing to start the green card process for you? And here we're really talking about both green card processes. One would be the standard process where they sponsor you. This does require them to take some preliminary steps, including, among other things, advertising to show that there are no U.S. workers for your job. And also, even before that, filing a prevailing wage determination application with the U.S. Department of Labor to make sure that the offered wage rate meets government requirements. So some employers say, look, we like you. We know you're going to be a great addition to our group. However, we want to wait 12 months and make sure that, it's working out. Or some employers may say, standard procedure is 90 days, and then we're happy to get started. Other employers will actually do the following, and I love when this happens. You sign the contract with them. The contract says they will actually start the process, at least the initial phase of it, once the contract is signed. Even though you're not working there yet, they can file the prevailing wage determination application. It's an administrative step. It's filed with the U.S. Department of Labor, and they can actually file that and get that going while you're completing your residency or fellowship. There's no legal requirement that you actually be working at your new job before this is started. So when an employer will put something like that in the contract, that is, that they will start the procedure for you early while you're still a resident or fellow, that is, they get an A+. Let's put it that way. They get an absolute A+ because they're giving you a head start on the green card process. It's a very slow process. And so being able to start 3 or 4 months early really does help. It gives you a jump start on the process. Now, If the employer says, we'd be willing to start this the minute you start working for us, that's fine too. That's more of a standard response that I've seen from employers over the years. It's pretty rare for an employer to start the process before you start working there. Here and there, they are willing to do it, but for the most part, they're willing to do it more often when you start working there. But again, if they are telling you that there's a waiting period, you really need to think twice about it. Again, the green card process is very slow. The earlier you start, the better. And if they start later, you have less time to get far enough into the green card process so as to qualify for an extension of H-1B status should you need it beyond the usual 6-year limit. Again, different types of green cards, but no matter what, you'll want to get this into the contract, and you'll want them to start or be willing to start and then go ahead and start as soon as possible. What to look for if you need a J-1 waiver. So this is for folks who are doing a residency or a fellowship as a J-1. So as a J-1, you'll need to speak with your employer not just about, let's say, an H-1B work visa or the green card process, but preliminarily it's important to speak with them about a J-1 waiver. Do they qualify to sponsor you for a J-1 waiver? Have they ever done it before? And the fact is that they would have to cover the cost of it. There are many different types of J-1 waiver procedures, and there are more all the time. It used to be way back in the day when I started out, there was one type of J-1 waiver and there were two, and now there are multiple types. So in addition to the Conrad 30 program that every state has, there are also other agencies like the U.S. Department of Health and Human Services, and then various other quasi-governmental agencies like Appalachian Regional Commission, Delta Regional Authority, Southern Crescent Regional Council, and others that sponsor them. So you'll want to find out, number one, does the location of the job qualify for a J-1 waiver? And if so, what type? Is it going to be a Conrad 30, like a state 30? Is it going to be an SCRC waiver? And if so, what are the requirements? What are your requirements? What are the employer's requirements? You want to make sure that everything is set up for success and that there is a game plan on how to handle this. In terms of the waivers, I mean, generally speaking, they all require that you work in the shortage job for a period of 3 years as an H-1B. They allow you to start the green card process, but not complete it during that time. And certain types of waiver sponsors will accept J-1 waiver applications for both primary care physicians and also specialists. On the other hand, some of these J-1 waiver programs will only accept applications from primary care physicians. For instance, in a state, let's say, where they're really looking to increase their access, the access of primary care in certain areas, and so priority is given to primary care physicians rather than specialists. So there are other types of J-1 waivers that don't require employer sponsorship, such as persecution waivers or exceptional hardship to a U.S. citizen. These waivers are waivers that you would file. They're complicated, and approval is definitely not guaranteed because it's discretionary by the U.S. Department of State and then the Immigration Service. Those types of waivers are actually something that we'll be focusing on a little bit later on, actually on October 17th. So join us on that day if you would like more information on these other types of waivers. Again, the persecution and also the exceptional hardship to a U.S. citizen, spouse, or child. What to do if your employer doesn't follow the contract? Once in a great while, I will get a call from somebody, whether it's an old client of mine, and actually more frequently than not, it's not a client of mine. It's someone who has heard of me or was referred to me by one of my old clients or even a current client. And the situation is this: the physician signed the contract, started work, holds an H-1B visa, or is in the green card process. And for whatever reason, either from the start or at some point after starting work, the employer is not living up to the terms and conditions of the contract. The employer, for instance, the contract says you're going to make XYZ amount of money and they're only paying you X. or the contract says that you're specifically working at one work location. And so your J1 waiver is based on that location. Your H1B is based on that location. And all of a sudden the employer says, actually, we want you to cover these other 5 work locations, even though they're not part of your J1 waiver, they're not part of your H1B. It's fine. Don't worry about it. Just go ahead and do it. We really need you to help us out here. We helped you by getting the J1 waiver. We're getting you a green card. So you got to be a good team player and help us out here. The government will never know, they'll never find out, and they won't care. Well, none of that is true. I mean, really, where to start here? The J1 waiver application, no matter what employment-based J1 waiver you do, whether it's a state Conrad 30 or an HHS, lists the specific location or locations where you're supposed to work, the rate of pay, etc. The H1B does the same thing, the specific rate of pay that you have to receive, and the work locations. Now, with all of this, it's fine if the employer wants to increase your rate of pay over what's listed. That's not a problem at all. People get raises periodically, no big deal, does not require any amendment to the J1 waiver, does not require any amendment to the H1B approval. The problem is if the employer suddenly says, I'm going to pay you less, I'm going to pay you $5,000 less, $10,000 less, I'm going to pay you 10 cents an hour. Obviously, it's a problem. You have bills to pay, but you know, the employer is violating the H1B, is employing the J1 waiver if there is one. And so at that point, rather than grinning and bearing it and say, okay, look, I'll take my 10 cents a day and just finish out this contract and get my J1 waiver done, and then I'll move on. You really need to contact an immigration lawyer, and probably will also need to loop in an employment lawyer too. Because if the employer is not living up to the terms and conditions of the contract and the H1B and the J1 waiver, it is really a problem. You should be able to, with the help of the immigration lawyer and the employment lawyer, get out of this horrible situation, get into a new work location with a new H1B and an amended J1 waiver, so that you're able to earn what you're supposed to earn. You're doing the type of work you're supposed to be doing. And this employer that went back on their word is basically out the door. And again, these lawyers that I mentioned can help you with that, and so can federal agencies. You know, the employer will be on the record with the Conrad 30 or whatever J1 waiver agency was used, also with immigration and the U.S. Department of Labor, in terms of their requirement to pay you XYZ, which is what all the documents say. If the employer is cheating you or shortchanging you, there are ways to contact these agencies and let them know, and in some cases seek their assistance to get back pay, interest, penalties, etc. So it's not as if an employer can unilaterally decide one day to change your working conditions and rate of pay, and you have no way to protect yourself or to get yourself out of what is quickly becoming a terrible situation. So there are ways to do it. Start with the immigration lawyer for first, and then possibly move on with employment lawyer and also with various agencies. And the lawyer really can be the conduit to those agencies. It's not like you have to personally contact those agencies yourself. Let the lawyer do it. The lawyer is more experienced with all of this. And by immigration lawyer, I don't mean the employer's immigration lawyer. This is a situation where you would independently want to retain and pay your own independent immigration lawyer. Using the employer's immigration lawyer obviously would be a complete conflict of interest. Their goal is most likely to protect the employer, so they're certainly not going to help you, especially if it includes perhaps reporting this type of violation to a federal agency. So this is when you would want to go contact your own immigration lawyer. You do not need the employer's permission to contact or retain your own immigration lawyer. You don't have to tell the employer that that's what you're doing. It's really none of the employer's business. At this point, you're trying to protect yourself from the employer. And so the last thing you want to do is clue in the employer and let them know that you're going to be contacting counsel to see what can be done about this terrible situation that they've put you into. Really at the end of the day, as it says at the bottom of this, depending on the nature of what's going on and whether the issues can be solved or whether it's just a situation that is so horrible you need to get out, there are ways to get out. if you're in the middle of your J1 waiver period, there are ways to amend it so that you can work in another location for a different employer, whether it's in the same state or sometimes they even allow you to go to a different state and complete whatever months or years you have left in a different shortage area so that you actually fulfill the full 3 years of the J1 waiver, and then you're officially done, even though you're no longer with the initial employer that sponsored the J1 waiver to begin with. Well, with all that being said, let's talk about what's coming up. First of all, I guess if you have any questions, feel free to ask them in the chat or email me about anything that was said here. At the end of the day, before I talk about what's coming soon, the best thing to do really is to take a step back. When you're in the thick of contract negotiations, like with anything else, sometimes it's good to take a timeout, to take a step back, go make yourself a cup of tea or coffee, and just take a breather for a couple minutes and really try and look at it as much as you can like an outsider, and look at this contract that's in front of you, or the amended contract if you've been negotiating and certain changes have been made. Is this something that you as an outsider would look at and would find to be reasonable? Good protections for both parties, and reasonable in terms of any non-compete clause or non-solicitation clause, and something that protects your interests. And also, does the contract say to you, look, this is a fair contract from an employer that really is trying to be fair and obviously really wants my services and is trying to do what they can, or as much as they can, to let me know through the terms of the contract that they're trying to be fair and they want to get everything off on the right foot, so that we have a long and productive working relationship for years and years to come. On the other hand, if you're drinking your tea or coffee and you take a look at this contract and you just start shaking your head like, yeah, there are some good things in this contract, and this employer seems pretty good, but at the end of the day, I see one or more real potential issues that could come back to haunt me a year from now, 2 years from now, maybe a month from now. It's at that point that you, looking at it as an outsider, would say, you know what? This contract really is not something that should be signed. This is something that should be set aside, and should be set aside, meaning don't sign it, shred it, get rid of it, move on, and try and find another employer that is willing to be more reasonable in terms of contracts, and then go with that employer. So with that being said, let's talk about what's coming up, coming soon. There's something new that we're announcing. We're working on it, so I don't have the exact information to give you, but just as a quick heads up, Ask Mike. It's an open forum for questions. And so what we're going to do is we're going to do that every Thursday in the evening, hoping that perhaps evening will be a little more convenient for some of the residents who aren't able to take time out of their day at lunchtime. And same with administrators and various managers of residency fellowship programs and others, perhaps in the evening after dinner with your evening cup of coffee or tea. You can join us in this open forum. It won't be a presentation as much as it will be taking your questions and answering them, and hopefully questions that will be helpful to everybody and answers that will be helpful also. And in addition, we'll probably, of course, also discuss some news of the day or news of the week, but just briefly. So there won't be any specific or formal slide presentation, but it's just your chance to join in, ask a question or two, stick around and see what kind of information may be helpful to you and the others. So over the coming weeks, we'll have more information about this, including the exact time and the format, and also the Zoom information, the meeting or webinar information. So stay tuned and look out for that. Next, if you have any questions, as always, let me know. Contact information is coming up at the end of this. And in terms of our next session, August 15th, 2024, the session will focus on visas for dependents, including H-4 visa status, J-2, and more. And by dependents, we mean, of course, spouse and children under 21 years of age. So what's involved in getting visa status for these folks, extending the visa status, and what are the parameters of these various visa statuses? Do they allow the person to work? Can the person volunteer? Can the person go to school or attend university? Well, stay tuned and join us on August 15th to find out the answers to all of these questions and more. In the meantime, I'd like to thank you all again very much for joining us today. for this presentation. I hope it was helpful. And as always, if you have questions, please let me know. And with that being said, I hope you guys all enjoy the rest of your day and the rest of your week. And look forward to seeing you on August 15th. Thank you all very much. Bye-bye.